Hey everybody, this is Tony Vernetti, the President and Founder of FEDS, Federal Employee Defense Services. Thank you for attending today's webinar on professional liability insurance. I've been working with your national leadership, NISMA, for several years now and have done specific information for them. Your region has asked us to put together a specific abbreviated webinar, if you will, for your regional meeting. So that's what we're doing here today. A little bit of information about myself. I am a former federal employee myself, and I was a federal attorney for many years at my old law firm where I defended federal employees, federal officials at a variety of different agencies. As I mentioned, these seminars typically take about an hour and a half, but we've been asked to do this abbreviated version for your meeting today. So I have a lot of material to get through in 15 minutes or so. So if you can hold your questions, obviously, until the end, we'll have somebody available to answer those questions. The first thing I want to emphasize is that the liability insurance, your agency is required to pay for half of it, up to one half of it, usually capped at $150, the reimbursement. Congress requires all federal agencies to reimburse managers, supervisors, and law enforcement officers this reimbursement. I'm starting the presentation with this because it's important to really understand and appreciate that this official support for liability insurance demonstrates Congress's understanding that there are risks associated with your federal employment that they cannot completely cure with legislation. Congress understands that you are vulnerable, that there are these risks out there, and they want to share the burden of the cost with you. When you think of liability insurance, think of liability insurance in three categories, where you have three areas of exposure: civil lawsuits, administrative and disciplinary matters, and criminal investigations. So what does liability insurance do? It provides a legal defense in the event that you are vulnerable to one of these areas, and two, it provides indemnity, which is money protection, liability protection, in the event there's a judgment entered against you. So we're going to start with civil suits, civil exposure. The liability insurance provides you with your own personal attorney to defend if you get sued. And the policy also indemnifies you up to $1 million or $2 million for a judgment of damages depending upon the policy that you choose. These civil lawsuits are typically referred to as Bivens actions, constitutional torts, personal capacity or individual capacity lawsuits. And they typically involve some very complicated legal principles. So this is not law school. I'm not going to jump into the weeds on that. So for purposes of today's discussion, all I want you to understand and take away is that you can be sued in your personal capacity, and you can be denied DOJ representation, and you can even be held personally liable even if DOJ represents you. You do not have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. So Fed's policy appoints you an attorney to defend in these personal capacity lawsuits when DOJ exercises its discretion not to defend you in the lawsuit. When does that happen? That most often happens if you are being investigated for some sort of wrongdoing for the very same reason that you're being sued. You can see that DOJ is not going to want to be on both sides of that. The Fed's policy will also appoint coverage counsel to monitor DOJ's defense of you, and particularly serious, egregious type cases are where we think there is potential for some vulnerability or sensitive matters. Feds may also hire coverage counsel to convince DOJ to provide representation if they're on the fence as to whether it's in the interest of the United States to represent you. Here are some real-world examples of civil lawsuits against federal managers, federal officials. That first one there is interesting. The employee who was fired during their probationary period, the judge allowed a personal lawsuit to go against the manager who essentially fired the employee for engaging in what we would call political activity. He was a retired military prosecutor from Guantanamo Bay, an employee of and then retired and was an employee of the Library of Congress in his probationary period, and he was very outspoken on the things that were going on in Guantanamo Bay. He was advised by his employer, the Library of Congress, that some of the things he was speaking out about was technically in violation of agency policy. He ignored, continued to write and speak out, and the agency fired him in his probationary period. The reason I'm mentioning that is because the manager did not make that decision by himself. He consulted with employee labor relations. He consulted with the agency lawyers, and it was the agency unit that decided to remove the employee, yet the manager is being sued personally. So I just think that's a good case to highlight for our purposes today. So just a real quick recap of civil. What I want you to take away is that you can be sued, you can be denied representation, and you can actually be liable for a judgment. And the liability insurance protects you in these three major ways: legal defense, coverage counsel, pays damages. Okay? A final point I want to make before we leave civil is that I do want to state that civil suits without DOJ representation are rare. Okay? They are rare, with actual liability being even rarer. Probably less than, I would say, 5% of the cases actually end up in denying representation and actual liability. Nevertheless, it can and does happen, so no matter what the percentages are, why would you risk it for $135 a year, which is the net cost after the agency reimbursement for the insurance? Moreover, the biggest bang for your buck for the liability insurance is coverage for these administrative matters. Okay? Any administrative investigation involving you that can result in a personnel action against you, you're going to be appointed an attorney to defend what I call cradle to grave, from the beginning of the investigation up into the conclusion. In the unfortunate event that there's a disciplinary action taken against you, we will defend both at the agency level, and if we have to appeal it to the Merit Systems Protection Board, we will also provide representation for that as well. What you need to appreciate is that whether your action is intentional or unintentional, you will be held accountable for even the most trivial or justifiable misuse or abuse of authority or violation of agency policy. It's just a new day for doing business throughout the federal government, not just at the Social Security Administration. And the name of the game is accountability. Here are some of the typical violations or investigations, the reasons Social Security managers have come under investigations. Some of this has been our experience. Certainly this list is not all inclusive, but we wanted to just give you a flavor for what's going on out there. And what also is going on out there, you very well know, the major challenge for Social Security managers is that you have rising workloads with less office staff to get the work done. Okay? Rising workload, less staff to get the work done. That type of environment usually adds to more scrutiny, more public scrutiny, politically motivated criticisms, accountability demands. You have a very active union, as you're well aware of, and some crazy bargaining unit employees. I can say that. You can't say that, but you know what I'm talking about. And complaints are simply on the rise. This slide, I just want to emphasize that for Social Security managers, allegations of wrongdoing or mistakes concerning your job, the government takes pretty serious, and it's pretty significant because of the potential for monetary losses to SSA's programs and the corresponding negative public impact that has. So as a result, no matter how trivial or frivolous the allegation may seem, the agency really feels that it's required to determine the validity of all allegations and determine if there's any substance to them. And they pretty much have to do that for transparency's sake. I just want to talk quickly about some of these investigations that can happen to you. And actually, before I get into that, if you don't know, the typical misconduct case in the Social Security Administration, usually a non-criminal type of violation is investigated. The process by which it goes is like this. It's developed by the field office, a processing center or some other SSA office. They will do the investigation themselves, and then if they think that there has been wrongdoing or some integrity violation, they'll then refer it to the Labor and Employee Relations staff for advice on whether they should take adverse actions or not. Other type of investigations are these Office of Inspector General investigations, Office of Special Counsel investigations, even congressional oversight and hearings. Often it's the career federal manager that gets served up by the politicals to have to go testify on Capitol Hill regarding some of the problems. I can't tell you how many times I've heard somebody say, when they're a subject of these types of very serious investigations, is, I didn't do anything wrong. And if I did, I surely can just go in there and explain. Or if I show up with a lawyer, if I quote lawyer up, they'll think I'm guilty. Okay? Can't tell you how many times I've heard that, and people, very naively go in there by themselves and almost always makes matters worse. The IG investigates fraud, waste, and abuse and employee misconduct. And believe me, they love making cases against federal officials. The higher up level the federal official, the more they start clawing at their desk. That's not to say their role in the government is not very important. It's just that I've seen a trend over the years of the IG wanting to make cases against federal officials at all costs. Even if it goes beyond what the initial allegations are, they really come in there and sort of throw everything against the wall and see what sticks. And when the weight of the government, federal government, is on you like that with a magnifying glass, I'm here to tell you that none of us are perfect. Quickly, I want to mention EEO complaints. I'm often told, why do I need my own lawyer for an EEO complaint? Isn't that a case against the agency? Isn't the agency the one that would be liable? Don't the agency have their own attorneys to defend these cases? Yes, to all that. That is true. But if there is a finding of discrimination or some other finding of wrongdoing, a big type settlement agreement, in light of some new laws, No Fear Act, other scrutiny that's being put out by the EEOC, reporting requirements, they will take action against the federal official for whatever their involvement was. So if you're a responsible management official in an EEO complaint, an RMO like we call them, even though the complaint's against the agency, it's important to get your own legal advice, if for nothing else, to be able to help the agency in its defense of the case. Your role in the process, whether you know it or not, is to establish what's called the legitimate, non-discriminatory reason for doing whatever it is you did or did not do. Got sort of tongue-tied there. But that's your role, and often it's not really explained to you that needs to really be established during the investigation phase, and it needs to be established by the affidavit and the evidence that you put forward. While the agency has lawyers to defend, and your interests and the agency's interests are often aligned, the agency attorney is still the agency's lawyer. Their duty of loyalty is to the agency. So they could be in a position where they're advancing an interest that's adverse to your own. So here are some examples of real-world matters that were covered for federal managers. Obviously, some of the facts have been changed a little bit to respect and protect attorney-client privilege. I'll just give you a second to read these. And here are some specific examples involving employees of your very agency that your leadership, NISMA leadership, asked us to consolidate and put out so that they can demonstrate to this membership the importance of getting this very important liability insurance, this very important protection. Because what was happening is NISMA members were having issues, were having problems, and they were coming to their leadership. They were having these employment-related problems, and they were coming to your leadership, and it's not that kind of organization. You're an advocacy organization. They're not prepared. They don't have lawyers that can represent you and help you defend. They recommend that you get this type of insurance, and that's why your leadership put out this message last year in March of 2001, and it was also ran in your Frontline newsletter. And I assume everybody got a copy of this, and I believe we'll be handing this message out with our slides as well. So just to sum up, for administrative matters, you'll be appointed an attorney to defend against the allegation, prepare you for the investigative process, attend the investigative interview with you if we're allowed. It's discretionary. You don't have a similar Weingarten right like bargaining unit employees do, and defend you in any resulting disciplinary action, both at the agency level and at the MSPB. The preparation for the interview, even if we are not allowed to attend, is a very, very important part of the process. And it's nice to have an independent, objective attorney advising you. While you may ultimately be vindicated with these allegations, the process, if you don't have liability insurance, costs you tens of thousands of dollars to hire your own attorney. You know, if you become the target of someone's misguided allegations or subject due to some other subject of investigation, you know, some act, error, omission, it can, you know, and you have to defend yourself. You have to go hire a lawyer. It can cost you a lot of money. The cost to hire a lawyer for just 1 hour of legal service costs more than the liability insurance. So quickly, I want to talk about criminal investigations. Now, I know everybody looks at this and their eyes get big. You didn't come to work today to violate criminal law. I get that. You know, majority of federal officials don't. But what you need to appreciate is that there is very little you can do wrong in the federal government and not also have it be a violation of Title 18, which is the criminal code. Some of the most common criminal investigations involve federal managers involve allegations of misuse of position or authority, conflict of interest statutes where intent is not a prerequisite to prove the crime, misappropriation of federal funds, release of Privacy Act or other statutorily protected information. I remember a case at the Social Security Administration several years ago involving the Office of Disability Adjudication and Review, ODAR, where they were the subject of an OIG investigation for allegedly reproducing evidence from one disability case to another. It was essentially a boilerplate interrogatory that people were putting in the decisions. In light of the backlog, they were trying to really churn and burn these decisions out, and the IG conducted a very serious investigation involving federal officials for that matter. Ultimately, that case was particularly negotiated out. Management got involved and worked with the IG to demonstrate that there was no real intentional wrongdoing going on. But if you had the liability insurance, you would have been fully covered for that kind of allegation. So just a summary of what the Fed's professional liability insurance covers. You have the $1 million or $2 million for indemnity protection and to defend you in a civil lawsuit, up to $200,000 for attorney's fees and administrative disciplinary matters, and then we just talked about the criminal stuff. A final point here, you know, I would say when I was an attorney in private practice, I witnessed people mortgaging their homes, depleting all their savings, you know, paying $50,000, $70,000, $100,000 of their own money. I used to always say I couldn't afford me. I would just go leave and get another job. But it really bothered me that I knew that if they just would have spent $135 a year, they would have been fully covered. And here's an illustration. We like to say you don't have to break the piggy bank to get the liability insurance. So as NISMA members, I failed to mention that you also get a $10 discount for being a NISMA member, and your discount code is either NISMA or SSA, depending upon whatever you want to put in or whatever you can remember at the time that you're getting enrolled. But $130 annually after you get reimbursed. And we do have payroll deduction available, $12 a pay period, I believe it is now, with your discount. So just think about what you spend $130 on. If you're going out to dinner tonight with your spouse or your significant other, you're probably going to pay that amount. This is my final slide, and I can't emphasize this point enough. You need to have the insurance in place before the incident happens, before the allegation is made. Can't tell you how many times people call us after their house is on fire. You cannot get in a car accident on Monday and try to buy your insurance on Wednesday. You need to have it in place. There are 3 ways to get enrolled. You can go, the easiest way, I think, is to go online at www.fedsprotection.com. We can send you an enrollment form. It's only 1 page. It takes less than 5 minutes to fill out and send to us. You can also just give us a call, and we'll get you enrolled over the phone. Again, it takes less than 5 minutes. And I think at the conclusion of today's presentation, they'll be handing out a flyer that does have an enrollment form on the back side. So that concludes my presentation. We will now, I believe we're going to have somebody available, if not myself, to answer your questions. But if we don't get to them, you can always just send me an email. You can send it to me personally. My email is Tony, T-O-N-Y, @fedsprotection.com. And, Learn Beauty, I think,